Kouri Richins was in court last week and a couple of weeks before that as well. It's Tuesday, it's January 6th, it's 2026. This case is getting ready for trial, and the filings, we're now over like 1,300 filings in this case. It is really very much in the, you get to the precipice of like a roller coaster and then you're on the big drop. This is on the big drop to trial before it goes into like loops and turns and all the rest of it. So we are now in the big drop towards trial where everything is getting filed. All the motions in limine, the motions to exclude. We still don't know about the walk the dog letter. And if the Kouri Richins case is not familiar to you and the walk the dog letter is not, she is the Utah woman accused of poisoning her husband. She's also charged with the attempted murder of her husband on Valentine's Day, just 10 days-ish before he passed away in early March. There are a lot of outstanding evidentiary issues that are going to be determined over the next few days, January 7th and 8th. The court has said very clearly no streaming of those hearings. It's going to be on delay in some way, which is fine because I don't imagine the rulings will be immediate. And what I have found from all the things in the Richins case is that even if the rulings aren't immediate, we learn quite a lot from the hearings. And that's what we're going to do today. We are going to cover the hearing from last week. And then there are some orders that the court has made that we are going to cover. And then I'll talk about generally what's outstanding for the motions in limine, motions regarding experts, etc.
Your Honor, did the court on January the 8th want to address the motion regarding Greg White's subpoena, Maria Bramwell's subpoena, and the motion to appoint counsel for Lisa Darden?
No, I'm hoping to rule on all of those.
The motion to appoint counsel for Lisa Darden. Now, we have talked about the defendant's mother in a few contexts. There are numerous lawsuits relating to this case in the estate of the victim. And we have gone over those ages ago. And in the estate civil cases, there's a lot of fighting over where money is, where money went, where marital funds went, whether money needs to be clawed back in to the estate, etc. In that, there are some allegations that Kouri Richins had taken money from marital assets and kind of funneled them towards her mother for the house that her mom was living in, etc., and that those should be clawed back in. So the estate is saying we need money back from the mother. Kouri has two criminal cases, the attempted murder case and then the financial fraud case with the mortgage fraud and the rest of it. There are references to her mom in there as well as somewhere that money went. Her mom is not a co-defendant. Her mom is not involved in that way. However, there's also in the criminal case, the walk the dog letter, which was written to Kouri's mother, telling Kouri's mother, it seemed to me, that Kouri's mother needed to tell the brother all of this strategy and stuff. And the prosecution in that was alleging that this might have been witness tampering. If Kouri's mother is going to be called to testify or subpoenaed to testify, there is still this insinuation out there that perhaps she might have been involved in speaking to witnesses, or even if it's her son, because it was like, hey, mom, tell brother XYZ. Even if brother's on board with what mom's saying, that still could be interfering or dissuading witnesses. What Kouri was doing, seemingly savvy enough, what Kouri was doing was writing out her letters and like holding them up to the screen on like the jail Zoom calls, thinking that if you don't say it, it's not recorded. Her defense attorneys have argued that the mother never saw the letter, and that because the mother never saw the letter, it can't be witness intimidation because it was never conveyed to Kouri's mom to convey it to the brother. Kouri's mom obviously knows everything that's in the walk the dog letter because it's been all over the media and it's on the court docket. There is still an ongoing motion as to whether or not the walk the dog letter will be admissible. But I think because the prosecution insinuated that this walk the dog letter might be a problem, that I would suspect Kouri's mother is like, if I'm being subpoenaed, do I need a lawyer? The answer is yes, you probably do.
The potential scope of testimony of Ms. Darden, Ms. Richins' mother, is a sensitive topic that may or may not implicate Ms. Darden's Fifth Amendment rights, may implicate a proffer of testimony or other evidence that may or may not be admissible. That all has the potential to affect the jury pool this close to trial. It has the potential to affect the voir dire process. Out of an abundance of caution, the court finds it is necessary to consider the motion to appoint counsel for Ms. Darden as a potential witness in a closed hearing in which the lawyers and the parties will be fully participating, but that will be sealed from public view or review.
At the hearing from January 2nd, 2026, Kouri Richins and her attorneys were in court via WebEx. The prosecution was in court. The judge, of course, in court. And with that, the hearing was really to make sure that everyone was on the same page before going into 2 days of hearings on January 7th and January 8th. Over those 2 days of hearings, they are going to be dealing with some hearings regarding experts, hearings regarding evidence, the beginning of motions in limine. The court said to the attorneys, it is an iterative process, meaning it is going to take some different steps to get through. They are going to do the first round of motions in limine, and the prosecution has asked for evidentiary rulings on certain things like the walk the dog letter that was recovered from Kouri Richins' jail cell, like a journal that was recovered in the search of Kouri Richins' house, and other things. So they're trying to get ahead of evidentiary rulings and have those argument before the jury's even selected. Those things can impact how jury selection goes, what's asked at jury selection, but it can also impact opening statements and really the order of the trial. So as much as they can, evidence that they know is going to be argued over or objected to, a lot of the time you can look at the arguments for it and start getting those rulings in early. With the Docket 214 letter, the defense has argued quite a lot of different ways why it should be kept out of evidence. And of course, the prosecution has argued many different ways it should be allowed into evidence. And it lays the groundwork in that walk the dog letter for some of the defendant's possible defenses. The defendant told her mother to tell her brother in the walk the dog letter, whether her mom saw it or not, we don't know, but said, hey, talk about the fact that the victim in this case, Eric, had weed gummies or would get them from Mexico. And, you know, maybe they were laced with fentanyl and maybe this and maybe that. So the arguments the defense is likely to make in trial are laid out by the defendant in this letter. And then if the defendant testifies, that letter is going to become even more necessary. As if the defendant's mother testifies and is like, yes, I know that the victim ingested this or could have done that. This letter seems to say it was more of a plan than the truth. So when you're looking at something like the walk the dog letter, those evidentiary arguments can be made in advance. You know what's going to happen. Now, there's other things that, of course, are going to happen during trial on the fly, and that's why the judge reminded. Part of it can happen in advance, but some of it's just going to happen once we get into trial. It can't all happen in advance. So on January 7th and 8th, there will be 2 days of hearings in the Kouri Richins case in Utah. The judge has again ordered no streaming. So how and when we will cover that? We will cover it. How and when we will cover it, like live versus not live, I guess everything's going to be not in real time, will be in the Lawnerd app. So if you are new to the Lawnerd community or new to this case, Lawnerd app at lawnerd.com. And I will tell you, if we need to shift around when we're streaming to accommodate for those hearings, I will keep you posted in the Lawnerd app. It is a free iOS and Android download. We built it for you and we're going to cover those hearings. It's just going to be a matter of when. I don't know if the judge is going to rule on everything on the bench. He does that often, but some of these things might be written rulings because they are going to impact the trial, especially when we look at things like the walk the dog letter. I'm interested to hear the arguments over the experts because the motions in limine really do give us a pretty broad view of what each side thinks the evidence will be. And I hope once this case gets ready for trial after jury selection, the judge changes his mind about no live streaming, but we won't know until we are closer to the end of February when this trial will start with evidence. The judge made a ruling regarding Kouri Richins' mom, and we're going to take a look at that ruling first. This is from January 2nd, so this was after the hearing. Before the court is defendant's motion to appoint counsel for Lisa Darden. Well, that's different than just having counsel. They want counsel appointed by the state. Based on the parties' briefing and counsel's argument on the record during a closed session on January 2nd, the court rules as follows. Defendant's motion to appoint counsel for Lisa Darden is denied without prejudice as moot under the current circumstances. That gives us nothing. Oh my God, you'll have nothing and you'll like it. You give us nothing. All right. State's reply in support of its motion to determine admissibility of the walk the dog letter. Statement of new matter. Is there new matter? The defendant's response to state's motion to determine the admissibility of the walk the dog letter overreaches legally and factually. As set forth in the motion, the first 3 pages of the walk the dog letter are admissible because the defendant's consciousness of guilt is relevant, more probative than unfairly prejudicial, and proves her intent, plan, and identity in causing Eric Richins' death. The defendant asserts that the walk the dog letter is not relevant because, quote, statements made in a vacuum cannot possibly be relevant. The defendant does not cite authority for this assertion because it is not true. Indeed, the defendant's consciousness of guilt is revealed in her writing of the walk the dog letter, not in anyone reading it. It says, moreover, contrary to the response, the walk the dog letter was not eternally locked in a vacuum. Rather, there is a strong inference that defendant intended to convey it to another individual. First, it is written to her mother. The day before the authorities recovered the walk the dog letter from defendant's jail cell, she rehearsed sending letter number 2 to her mother using HomeWave's video feature to bypass the jail's normal mail screening. And then they cite where that is in the docket. Regardless, it simply does not matter that the authorities seized the letter before the defendant sent it to her mother. The defendant asserts that the walk the dog letter is not consciousness of guilt evidence because, quote, the statements in the letter can just as easily be interpreted as a reminder as to what defendant's brother can truthfully testify about. It goes on to say, this interpretation, however, is highly unlikely given the defendant's lengthy and repeated explanation that the walk the dog letter is a, quote, sloppy rough draft of a, quote, freaking book wholly unconnected to Eric Richins' death. Emily, where do these statements come from that the prosecution is quoting? Jail calls. They come from jail calls. We have only seen transcripts of these calls. I cannot wait to hear these in trial. I am very interested. Moreover, contrary to the response, presenting the walk the dog letter to the jury will not confuse and mislead the jurors into thinking that they are deciding a witness tampering case instead of an aggravated murder case. Jurors are smarter than that. Is she telling her brother and mother to lie for her? And is she doing that because she knows she did something wrong? That's the question. Conclusion, the court should determine that the first 3 pages of the walk the dog letter as redacted, consistent with the court's privilege determination, is admissible for trial as a statement of a party opponent. Her words, Your Honor, her words. Let them in. We want to hear it. So this is the ruling and order denying defendant's motion to reconsider bail and release. The defense asked with new circumstances, can you let Kouri out now? Because one of the witnesses said that he doesn't remember selling fentanyl specifically. He was selling Oxy or Roxy and not fentanyl. So does she get out now? Because he sold things to Carmen, but he thought the things were different. Before the court is defendant Kouri Richins' second motion to reconsider bail and conditions of release, through which the defendant requests that the court reconsider its previous detention ruling and grant her the privilege of pretrial release. Under Utah Code, section cited, defendant may move to modify the court's pretrial detention order only upon a showing where there has been a material change in circumstances. You're going to take the easy road, aren't you, Your Honor? You're going to just be like, this motion is not appropriate at this time because there's been no change in circumstances. Defendant asserts that there has been a material change in circumstances because recent statements by one of the state's witnesses, Mr. Crozier, changes the landscape to a degree that cannot be ignored. Specifically, defendant asserts Mr. Crozier's recent recantation of his prior statement that he sold pills containing fentanyl to Ms. Luber, that's Carmen, changes the evidentiary landscape in a way that precludes a finding of substantial evidence to support the charge of aggravated murder. On November 12th, 2024, the court heard argument on defendant's first motion to reconsider bail and conditions of release. Notably, defendant did not challenge the court's determination regarding substantial evidence to support the charge of aggravated murder. Rather, defendant argued that less restrictive conditions were reasonably available to ensure public safety and guard against defendant's risk of flight. The court denied defendant's motion for the reasons stated on the record. But now, through her second motion to reconsider bail conditions of release, defendant does challenge the court's determination regarding substantial evidence. Specifically, defendant asserts that Mr. Crozier's recent recantation of his prior statement that he sold pills containing fentanyl to Ms. Luber changes the evidentiary landscape in a way that precludes a finding of substantial evidence to support the charge of aggravated murder. The parties' briefing shows some ambiguity has arisen regarding Mr. Crozier's recollection of whether he sold fentanyl pills to Ms. Luber. Right. Was it fentanyl or was it like street oxy? You know what didn't change? He never said, no, I never sold pills to anybody. His belief of what the pills were is what changed. That's it. On May 4th, 2023, during an interview with Summit County detectives, Crozier confirmed that he sold fentanyl to Ms. Luber. Further, he rejected the possibility that Ms. Luber asked for oxys or something like that and got fentanyl instead. On March 28th, 2025, Crozier participated in a trial participation interview with Chief Prosecutor Brad Bloodworth and Chief Investigator Travis Hopper. Mr. Hopper remembers the following from that interaction. Mr. Bloodworth reviewed his outline summarizing the information obtained from May 2023 with Mr. Crozier. Mr. Crozier did not say that any part of the outline was false or misleading. That's new information. Mr. Crozier did state that he was unable to recall all the details because the events being discussed had occurred approximately 3 years earlier. Reasonable. In two affidavits signed on April 10th, 2025, Crozier tells a different story. So in March 2025, he didn't say it was wrong. He's like, my memory's gotten a little fuzzy. But then in September, he tells a different story. Crozier states that during the trial preparation interview with Mr. Bloodworth and Mr. Hopper, he told them that he was certain that he sold Carmen OxyContin 30 milligram pills, otherwise known as Roxys or Roxy 30s. This is what he told the defense. Crozier explains that in early 2022, he knew the term, quote, blues to mean OxyContin. He asserts that he did not associate the term blues with fentanyl until late 2022. He asserts that he did not begin selling fentanyl until the end of 2022. Footnote 3, the court may properly consider Mr. Hopper's affidavit and his recollection of what Mr. Crozier said because the Utah rules of evidence, including rules regarding hearsay, do not apply to proceedings with respect to the release on bail or otherwise. It goes on to say, Crozier explains that he was very confused and very out of it when he interviewed in May 2023 because he was detoxing from drugs. Ruling. A party may move to amend a pretrial detention order only upon a showing that there has been a material change of circumstances. Defendant asserts that there was, based on Crozier's statements. The court goes on to summarize the defense argument thusly, saying specifically defendant argues that because Mr. Crozier now asserts that he sold only OxyContin to Ms. Luber and he did not begin selling fentanyl till late 2022, there is insufficient evidence to permit a reasonable jury to find beyond a reasonable doubt that defendant was in possession of fentanyl in 2022 or that she could have used it to kill her husband. Therefore, defendant argues that there has been a material change in circumstances that requires the court to hold a detention hearing and determine conditions of defendant's release. Defendant's argument is unpersuasive for 3 reasons. Oh, only 3? First, a reasonable jury could choose to credit Mr. Crozier's statements to detectives in May 2023 over his statements in September 2025, given that they were made 2 years closer in time to the events in question. His retraction of his former statement does not render his former statement inadmissible. Second, defendant fails to acknowledge or address the other evidence from which a reasonable jury could find defendant had a motive to commit the crime charged and exhibited consciousness of guilt. Mr. Crozier's recent recantation, and I disagree with the framing of that, Mr. Crozier's recent statement does not affect the weight of that evidence at all. Period, Your Honor. Third, defendant's argument implicitly misunderstands. I agree. Defendant's argument implicitly misunderstands the substantial evidence standards. In determining whether the state has shown substantial evidence to support the charge of aggravated murder, the court is not required to determine that a reasonable jury will, would, or is likely to convict defendant. Accordingly, the court determines the defendant has failed to show a material change in circumstances. Accordingly, we're not hearing your motion. Get out. Yeet. Denied. There was an additional motion to compel regarding the victim's sister. Before the court is defendant's motion to compel Kouri Richins-Benson to comply with subpoena, or SDT, subpoena ducis tecum, which requests an order requiring Katie to comply with the following portions of the subpoena. We went through this. Katie's lawyer responded and was like, what the fuck are you even on? They asked for specifically all documentation in your possession or control showing the financial activities of the Eric Richins Living Trust dated November 3rd, 2020 from March 3rd, 2022 to present. And then copies of checks drawn out of your personal or business checking accounts made payable to any individuals connected in any way to the investigation or prosecution of Kouri Richins. I remember this. Defendant's motion to compel is denied without prejudice for two reasons. First, defendant has not complied with the requirement to meet and confer with opposing counsel in an effort to resolve this dispute without court action. God, I just love it when the court follows the rules. Thanks, Your Honor. Second, the categories of information described in paragraphs 5 and 6 of the subpoena quoted above, as currently drafted, are overly broad and unduly burdensome, which counsel also argued. Moreover, because defendant's counsel did not conduct a meet and confer with counsel for the trust or for Kouri Richins-Benson, the court does not have the benefit of counsel's discussions regarding whether the scope of paragraphs 5 and 6 may reasonably be narrowed. For those reasons, the court denies the defendant's motion to compel Kouri Richins-Benson to comply without prejudice. The court encourages defense counsel to conduct a good faith meet and confer with counsel for the trust and Ms. Richins-Benson to determine whether the scope of the information sought by defendant may reasonably be narrowed. Following that meet and confer, if a dispute regarding subpoena compliance persists, defendant may file a statement of discovery issues under Rule 37 of the Utah Rules of Civil Procedure. So the court's like, yeah, that's ridiculous. We're not doing all that. It's too much. We covered the latest Kouri Richins hearing as they were preparing for the 2 days of evidentiary hearings ahead of trial. We are waiting on decisions about the walk the dog letter and what will come in. I think it will be partly redacted and then will come in. And we covered some of the judge's rulings denying the defense's motions to compel Kouri Richins-Benson, who is the executor of the estate and the victim's sister, the sister-in-law or former sister-in-law of the defendant. And the defense was trying to compel quite a lot of documents. The court's like, you need to narrow this down and you need to have a meet and confer. The court was silent on the question of sanctions that the civil attorney had asked for. We'll see if that goes anywhere else with the sanctions. Probably not, but hopefully they will meet and confer and then we'll see. We also saw the court denying Kouri Richins' really third attempt at being released from custody. And the court was like, there is not a change of circumstance here. Remember, the defense was arguing that one of the witnesses had retracted their whole statement and the entire prosecution case had collapsed like a fifth grade mission project made out of spaghetti. And well, that's not what happened at all, actually. It was that might be a change of statement. It might be memory has lapsed over time. We're just going to have to wait and see till we get to trial. And the court said, there's no change of circumstance here. I'm denying this motion. Kouri Richins remains in custody pending trial. And there's going to be a lot happening in this case as we get closer to trial. And there is still this really interesting question that came up in the hearing today about appointing an attorney for Kouri Richins' mother. The court said that the issue was moot. I don't know if that's because Kouri's mom has hired an attorney. I don't know if that's because Kouri's mom is going to testify, not testify, but there is still this lingering issue of whether or not Kouri Richins' mom is going to testify, if there's a Fifth Amendment privilege there, and if she has retained her own attorney. Because at one point, the defense had asked that she have counsel appointed for her. And it seems that that's not an issue that's going to be taken up at this point. But why? I want to know what's going to happen. So we have lots of Kouri Richins to cover this week. I know there are other things that have gone on over the time that I was off. I will be doing my best to keep up on new things and other things, but I do try to stagger cases so they are closer in time to what's going on. So Murdaugh, I'm going to cover closer in time to when he's going to be back in front of the Supreme Court, just so it's in time as best we can. And since Kouri is this week, I thought it was helpful today, since we weren't going to be in court in Massachusetts, to circle back on all the things that we hadn't covered yet, because Kouri just had to wait. There were other women that were in trial, Kouri. You're not the only one. You'll have our full attention soon, but not just yet, because we have lots of other cases to cover. And don't forget to get the Law Nerd app, because if you get the Law Nerd app, you will stay in the loop when we are covering court live, when we are covering documents that can be, well, very dramatic, and when the schedule shifts around, and updates on cases that we're covering as they happen. That is where I send out notifications like, oh my God, this thing just happened in this case. That's where I keep you up to date. Thanks for joining me. If you enjoyed this episode and don't want to miss updates on your favorite cases, you're going to need the Law Nerd app at lawnerdapp.com. That way you can stay in the loop on the cases that matter most to you, and you never know when you're going to catch feelings for a new case. So make sure you get it for free on iOS and Android. Thank you for being here, and thank you for being a Law Nerd.